All right, today we're not short-handed or whatever because we have a wonderful speaker here, and it's I'm going to tell you about Ed Yohnka, who is the Director of Communications and Public Policy for the American Civil Liberties Union, and he's going to pick up the cudgel something, and talk that what Colleen was going to talk about, and he comes with great reputation. So, but I want to begin by saying that less than 2 weeks ago, the U.S. government and our democracy barely survived an economic disaster that could have spread around the world. Most of us caught our breath after cooler heads decided that the federal government had to pay its bills, raise the debt ceiling, and go back to business as usual. Our democracy was saved and we could relax. Sadly, that is not the case. Our democracy was saved. Well, the U.S. Supreme Court, the reason we can't relax is that the U.S. Supreme Court is getting ready to rule on some major issues before the current term expires at the end of this month. These issues include some basic values, such as voting rights, free speech, immigration, affirmative action, LGBTQ rights, religious rights, and student loan forgiveness. They've got a lot on their plate to finish, to report on before the end of the month. In the meantime, as a result of the Roe versus Wade, Hobbs-Jackson decision, there is no constitutional right to abortion, and millions of American women are not guaranteed abortion care. What are we going to do about it? Well, we have Ed Yohnka here today from the American Civil Liberties Union, and we'll discuss that. And I'm going to finish in just 1 second. He is the Director of Communications and Public Policy for the ACLU. Before he joined the ACLU, I just want to say he's got an impressive resume, but I'm not going to read it all. From 1987 to 1999, Ed Yohnka served on the staff of the American Bar Association, spending most of that time as a special presidential assistant in the American Bar Association office. In his role, Ed Yohnka directed and oversaw the development and implementation of communication vehicles for the elected leadership of the world's largest professional association. By the way, there are 70,000 members and supporters of the ACLU. So without further ado, I've said enough. Let's give a big welcome to Ed Yohnka.
Thank you so much. Let me first of all pass along Colleen's greetings to all of you. I talked to her on the way up here today, and she apologized for not being here. I do want to say just a note of personal privilege, if I might, before I begin my remarks. It's always something to learn that you're going to go do a set of remarks 24 hours before they're scheduled to be given, and then walk in and hear repeated 2 or 3 times that you're part of a world-class program. I don't want to say that it's a little bit intimidating, but it is a little bit intimidating, as you might imagine. But I was put at ease because had you just told me we were going to do quotes from the Godfather movies, I'd have come up here whether I was speaking or not. I have a friend with whom occasionally we will just start in the middle of the day for no particular reason texting back quotes from the Godfather movies, and it really is great entertainment if you'll find someone who will do it with you. And all of life's wisdom is contained in the first 2 movies. I will leave it at that. Let me just say one last thing before I begin, which is Don's remarks about our democracy, I think are really profound and important today of all days. All of us of a certain gentle age have never imagined a time in which a former president of the United States would be arraigned on a federal charge involving, state secrets and the possession of documents and obstruction of justice. And I think even in the last couple of days, sort of the amped up threats that we have seen, threats of violence or other kinds of threats to defund the FBI. I always thought that was an ACLU dream. I didn't realize we shared it with others. But I think that this notion about what we are as a democratic society, what our rule of law means, and what it means in a free society to say and to truly intend that no one is above the law is something that we're clearly going to be tested on over the next several months and several years. And I think the question I am always drawn and always have been to that great quote from Benjamin Franklin, who emerged from the Constitutional Convention, and somebody said, "What kind of government have you given us?" And he said, "A republic if you can keep it." And I think it's a reminder that we're always challenged about the ways in which we keep it. And this is just another one of those moments for all of us to think about, again, sort of what role we play in that and how important that republic is to us. So let me talk a little bit about where we are in the country with regards to access to abortion care. I want to talk a little bit about how we got here, a little bit about where we are, and I think, sort of look at what's happening both here in Illinois and sort of cast that out into the future. And I begin with the notion, as Don said in the introduction, we are moving quickly to the end of this particular term of the Supreme Court. And we all remember last year. So in just a few days, we will reach the 1-year anniversary of the Supreme Court's decision in Dobbs v. Jackson's Whole Women Healthcare, which stripped away the fundamental right for people who become pregnant, women, to decide whether or not they're going to carry a pregnancy to term, and to make that decision on their own without any governmental interference. And I think it's fair to say, as we think back over this last year, that that decision has had a remarkable impact in terms of our society. It's having an impact in terms of the availability of healthcare, which I will talk about. And it's had a really profound impact in terms of our politics. We are seeing things that we could not imagine before in terms of our politics. And so I think it is a matter that is worth contemplating and thinking about and considering in terms of what kind of a society and what kind of a place we want to build, not only for ourselves, but for our daughters and our nieces and our grandchildren as we move forward. So let me say, I think a quick thing in this audience, probably that everybody knows, that the right to abortion was recognized, and I use that word deliberately. It was not identified, it was not named, but it was recognized as part of an emerging body of law around privacy in the decision of Roe v. Wade in 1972. And at that time, what the court fundamentally said is that our Constitution creates a series, basically kind of a kind of an aura of privacy and rights around us that allow us to make our most fundamental decisions without government telling us what to do. This was from the same string of decisions that not only had recognized the right of people to make decisions about the use or not using contraceptives, but also about the right to marry who you love, right? The Loving versus Virginia case that decided that interracial marriage could not be barred by law. There was this notion that our Constitution really fundamentally makes each of us a whole human being, and we get to make decisions about how we use that and how we create the person that we want to become. My mother, God rest her soul, is still disappointed in what I've done with that decision, but perhaps some of you have done better with your children. And so, you know, that ideal was fundamentally that we get to make these decisions. That decision in Roe was upheld several times over the years, including most critically in 1992 in the Casey versus Planned Parenthood case out of Pennsylvania, in which the Pennsylvania General Assembly had attempted to impose restrictions on abortion care that went far beyond what were prescribed by Roe. And the court said, no, Roe is the settled law of the land. This is what and therefore that right to abortion is recognized for people pre-viability. And so that was the decision without an emergency, without an exception. And so that was what was recognized. And that came to be known, for any of you C-SPAN junkies, if you ever watched hearings for Supreme Court nominees, that came to be known as something that was called a super precedent. It was not only a precedent, it was a super precedent because the court had not only considered it, but had recognized it and re-recognized it and recognized it again. And therefore, we were always assured the matter had been settled. So what changed? Did the Constitution change? Did the law change? Did anything scientifically change in terms of our understanding of pregnancy? Did anything change economically or societally that made us think would have thought different? In fact, the one thing we know is if you actually track from Roe on forward, we see the growth of opportunity and availability for women to seek education, career opportunity and advancement, and other things because they could control when and if they would get pregnant and when and if they would have a child. What I would suggest to you was that the only thing that changed over the last several years was the personnel of the court. And so fundamentally, this is not a legal decision that comes in Dobbs. This is a personnel decision. When the court shifted to the right, when the former president was able to nominate 3 people whom he promised would overturn Roe v. Wade. That's what he promised. That's what he said in his campaign. He was given a list by the Federalist Society to tell him who those people were. He nominated those people. We don't need to relive the fact that, you know, the Senate denied Merrick Garland even a hearing for consideration, then rushed through Neil Gorsuch, then Brett Kavanaugh, and then of course, even after people had started voting in an election where they rejected the president of the United States and actually turned control of the Senate over to the other party, they pushed through Amy Coney Barrett, giving the majority to those people who had promised to do that. But I think there's another element of this that really we don't, maybe I think sometimes we don't talk about this enough, and maybe it isn't news to you, was that literally as that court was changing, states were passing laws which were designed for one and only one purpose. And that purpose was to get a case before the Supreme Court that would in fact overturn Roe v. Wade. The ultimate vehicle for that was a Mississippi law that banned most abortion, and that became the challenge in Dobbs v. Jackson's Whole Women's Health. And the Supreme Court took that case. The case was argued before the court, and they issued a decision in which, of course, number one, in the matter of a few sentences, they overturned Roe v. Wade. This super precedent, this matter that had been settled law, this thing that would not necessarily be overturned, was overturned in a matter of a paragraph. The second thing, of course, was that they argued that the government had a significant interest in overseeing this kind of care as compared to all others, which again does this othering or singling out of abortion care for some different kind of scrutiny and some different kind of regulation than any other care. I am reminded years and years ago in a different case on the Seventh Circuit, then Judge Richard Posner, who was really an incredible writer and an incredible jurist, didn't always agree with him, but just was somebody who was amazing to watch. But once said that if you actually, because these were around these so-called partial birth abortion cases, and that often in arguments in court, they would describe these gruesome practices. And so Judge Posner then described in vivid detail certain different kinds of surgery, from pancreatic surgery to prostate surgery. And he said, if all we have to do is describe something that is gruesome, we're going to have to put these regulations on everything. And it showed in which the way in which there was this specific strain of cases and this specific effort to put the spotlight on one certain type of care, abortion care, in this case, in order to overturn it. The second thing that the Dobbs decision did that we should sort of establish and talk about a little bit is that they promised, and in fact, Justice Kavanaugh wrote a concurring opinion in order to make this point specifically, that all they were doing was returning this to the states, for the states to decide whether or not abortion care would be available. We'll get to how that's working out in a little bit. But the third thing, and I think this is the thing that we have to keep in mind even as we discuss abortion care, is the concurring opinion that came from Justice Thomas in this case, in which Justice Thomas said, and literally invited people to bring challenges, arguing that if you look at the strain of cases from which Roe came, that you could not distinguish, for example, the ability to marry the person you love. You could not distinguish any gay or lesbian rights cases, and you could not distinguish access to contraceptives. And so what Justice Thomas said is, bring us those cases. Let's do those next. And, you know, if you think about the fact that the underpinnings of Roe, the basic privacy right that's being implicated, is the same in those other matters about one's personal autonomy and one's personal decision-making, he's not wrong to link them. It is a little frightening. He's inviting people to bring these cases, but he's not wrong to link them together with the idea that they could, that the court might also strike those rights down. So Dobbs gets issued. And what is the impact and what are we seeing? So to begin with, in the year since Dobbs has been in place, we now have 20 states in which abortion is completely or totally banned. We have 5 to 10 states that are working on additional bans. And we have a couple of states where, there is a different level of work being done, what happened was many of these 20 states actually had laws on the books that were so-called trigger laws. The legislature had passed, the governor of those states had signed many years ago a bill that said, if Roe v. Wade is overturned, we will ban abortion. And so in many states, those laws snapped into effect immediately on the Dobbs decision being issued. Now, in many of the states, there was still litigation around that. There's sometimes a state constitutional question as to whether the General Assembly or legislature from one era can bind a legislature from another era. In some cases, states had to pass a new ban or a new or additional ban. In other cases, that the trigger law was allowed to go into effect. And the other thing that's happened around the country is there's been a lot of litigation around whether or not a state constitution actually provides more protections in terms of privacy and bodily autonomy than does the federal constitution. It is worth remembering, for example, that the federal constitution was created in the 18th century, and the Illinois Constitution, just to pick an example, was created in the 20th century. We learned a little bit over those 2 centuries. And so, one should always think of the federal Constitution as being the floor for any individual rights and not the ceiling. States are still allowed to provide protections that go beyond in individual rights what the federal Constitution mandates. And so in many states, what they discovered is their state constitution, this is, by the way, the thing that happened in Kansas, was that their state constitution actually provided protections for healthcare decision-making, including abortion care. Then they tried to overturn that through an amendment process to their constitution, which was defeated overwhelmingly at the ballot box last August. And so that's one of the kinds of activities that we've seen at the states. And I think the other thing that we're seeing as you look around is this idea of kind of rushing to the bottom. The latest example of this seems to be, if you look at Nebraska or Florida or South Carolina, these efforts to ban any procedure after 6 weeks, which is, of course, far earlier than many people actually know or understand that they are pregnant. And so this idea to kind of block at all terms what's happening. So that's one outcome we've seen, is this action and activity in the states. The second thing I think we're clearly seeing is what is really the kind of desperate healthcare crisis that's being created by the post-Dobbs world. Number one, once you have a criminal statute that says if you do a procedure, you could be liable criminally, it is just a natural condition that medical professionals will stay as far away from that line as humanly possible. Most of us do not want to violate the law and risk losing our liberty. And so what we've seen in these 20 states or more that have passed restrictions or outright bans is we're seeing a denial of medical care in situations, complicated, problematic pregnancies in which for years, healthcare professionals would often provide care, would provide abortion care in order to preserve the life, the health, or the future fertility of a mother. Those services are no longer being provided. And what we're seeing is people having to travel far distances in order to get health care, not because they don't want to continue a pregnancy, but because a pregnancy that is very, very much wanted puts them at risk to their own health, puts them at risk to their own family, and losing their family and leaving children behind. And so what we are seeing again across the country is this lack of care that's available as a result of these bans, because again, doctors want to move away from those. And it's doing one more thing that I think is something that, you know, again, logically, we can all think about it being the natural outcome, which is that we are actually now seeing OBGYN deserts across this country, where people who practice obstetrics and gynecology do not want to practice in a state where simply serving their patients may put them at risk of a criminal charge. And so, you know, you have circumstances in Idaho recently and in other states where people are having to travel long distances, not to seek abortion care, but simply to seek basic health care because of what's happening. And so we're seeing this division kind of rend across the country in terms of this basic availability of fundamental care as the result of what we're seeing happen. So let me turn then, as I promised, to this issue that, as we were told and assured, that all the Dobbs decision would do was return this issue to the states, right? We're going to return this issue to the states. We're going to let the states decide. We're not going to, you know, nobody's trying to create any national bans. That's not what this is. Again, that might not have been true. Because it took less than 2 months for federal legislators to propose a national ban or to propose national limits on abortion care, not leaving it to Illinois to decide what they want to do and Missouri to decide what they want to do. They wanted to let Congress decide for all of us what we should do. And I think that kind of thing is, you know, is something that we need to pay attention to, because I would argue candidly that the purpose of this movement that worked for 40 years to get to the reversal of Roe v. Wade and Dobbs was never about returning it to the states. It has always been about banning and eliminating as many abortions as possibly can happen across the country. And the second place in which we're seeing this is in the litigation that I'm sure that all of you have read about or heard about or talked to friends about with regards to the medication mifepristone. So let me just say, by way of background, that mifepristone is the safest and most widely used abortion medication in the country. It was approved by the FDA for use in 1999. So in 1999, the FDA approves mifepristone for use. It has been in use since that time. It has been proven to be safe and effective. There are peer-reviewed studies that show that there are less adverse effects to the use of mifepristone than there are to Tylenol. Last year, a group of doctors formed an organization in a little town in Texas. And because their organization was formed and incorporated in this small town in Texas, they were able to file a case challenging the 20-some-odd-year-old approval of mifepristone in a district court in Texas where there is only one judge. That judge actually wrote a law review article about how mifepristone should be banned. And they make this argument, they make two fundamental arguments in this case. The first is that they argue that the mifepristone process was rushed and wasn't scientifically accurate in terms of the information that was used to approve the medication. The problem with that argument was back in 1999, that was the end of a 6-year process to get mifepristone approved, and it was only approved with a series of regulations that most medications weren't facing at that time. In fact, those were not, some of those regulations were actually not rolled back until the Biden administration. So number one, they argue over a 20-year-old process that happened, saying that it wasn't carried out in the most appropriate or correct way. And the second thing that they argue is that even setting aside that there is a law from the 1870s, forgive me, called the Comstock Act. And that the Comstock Act, which banned the use of the mail to send any kind of materials that were considered pornographic or would be related to terminating a pregnancy, that they say that the Comstock Act from the 19th century bars the use of mifepristone because mifepristone is then mailed across the country to patients for whom it's been prescribed. Now, a couple of things. I would like to think that maybe we have advanced a little bit since the 19th century in terms of our understanding about medication and the use of the mails and other things to send it. Secondly, it's interesting that there is no effort to bar, for example, the mail for the distribution of pornography. We're just going to do it for mifepristone. And number three, actually Congress, the Justice Department, and courts have long since recognized that if a drug is FDA approved, that it should not be considered, even if one considers the Comstock Act still viable. It wouldn't be applicable under that act. So the judge in the case in Texas, in this small one-judge district in Texas, actually found that mifepristone was approved in a negligent fashion by the FDA and said that he would remove it from the market. Not just, of course, in the states that have decided they don't want it, but literally in every state across the country. If you withdraw or force the FDA to withdraw approval, it's not simply for Alabama, it's for Illinois. That case went up to, he gave 7 days for the FDA to appeal the decision. The FDA appealed the decision to the Fifth Circuit in New Orleans. The Fifth Circuit took the case, and a 3-judge panel in New Orleans said that they weren't sure, basically, they weren't sure that they would withdraw approval completely, but what they did want to do was go back to the 1999 rules for the use of mifepristone, which included things like a patient having to make multiple trips to the doctor in order to be prescribed. It had to be, there were other things in terms of the doctors who could issue those issue the prescriptions, how the prescriptions were filled, and et cetera. So again, even if you don't have the withdrawal taking place completely, you have this severe limitation on something that is a safe and widely used piece of medication. And then the Supreme Court got an appeal from the FDA. And as you know, the Supreme Court stayed the enforcement of any of these notions and sent this case back to the Fifth Circuit, which heard arguments on it a few weeks ago, and we're awaiting a decision. But I think this case obviously is headed back to the Supreme Court. It is not clear that the court, again, didn't take the matter up and blocked enforcement of any of these lower court orders. But again, I think we don't know how it would come out in terms of an argument in the Supreme Court. And one of the things that we're seeing is this kind of effort to get these kinds of cases up to the Supreme Court in order to get, again, these kinds of decisions that have a nationwide impact. There is similarly from Arizona, a case in which there is an attempt to actually designate a fetus as a person with all the legal rights of anyone else. That, of course, would bar any kind of access to abortion care anywhere across the country. And I think we'll see cases like that percolating up as we go through the next few years. And what it means, of course, is that we are not safe in terms of protecting care in any given state. That there is still this effort to nationalize bans and nationalize limitations in a very significant way. So having said all that, let me just talk for a minute about what the state of play is here in Illinois, and then a little bit about, I think, where we go from here. So first of all, let me say that as I describe all these changes, and this is one of the reasons that I have always been for the last 25 years, and I remain sort of proud to do the work I do through the ACLU, because candidly, we saw this coming several years ago. We recognized that at some point, giving changing dynamics, giving the possibilities for change on the Supreme Court, that you could see a day in which a decision like Dobbs might well be issued. And so we began what was a 3-year program to really try to address these issues. And we did a couple of things through the legislature. The first was Illinois had in the 1970s, shortly after Roe v. Wade, the legislature passed, the governor signed a so-called trigger law. So the very first thing that we did was pass a measure a few years ago that removed the trigger from Illinois law, so that even if Roe v. Wade was overturned, Illinois would not be one of those states that would snap back to our 1970s or 1930s, or in the case of Wisconsin, 1870 abortion law. That was the first thing. And then we looked at the fact that there had been a series of measures that had passed in the 1960s and the 1970s in Illinois, all of which had been blocked by the courts from enforcement, that did things like, force a 48-hour waiting period before someone could seek abortion care. It forced a woman seeking abortion care to get the written permission of their husband or partner before they were able to seek this health care. It placed all kinds of other limitations. It had one was before anyone could seek abortion care, they had to listen to a government mandated lecture on abortion that included a bunch of medically inaccurate information about the impact of abortion care on people. So all of these laws were in place, and we worried about that, and worried about if Roe fell, many of those were blocked on the basis of Roe. So then we helped with a group of people to write and pass something called the Reproductive Health Act. And I will not bore you, I promise you, with all the provisions of the Reproductive Health Act, because the most important thing to know is it says that any person in Illinois can make any decision about their reproductive health without government interference. That's not just abortion care, that's about fertility care. It's about a whole range of other cares. These are things that we get to do that government doesn't get to interfere with. And that was passed in 2019 and signed into law so that when Dobbs fell, we actually had these protections in place. This year, in January, we added one more protection because of, again, I think back to this idea of returning it to the states, something that we're seeing that I think is an especially dangerous or sort of precarious kind of development, which is in many states, they are considering. Idaho recently passed a measure like this, a law that actually criminalizes someone going to another state to get care that is legal in that state. That once they banned it in their state, they're saying, we will use the power of government and law enforcement to determine whether or not you went and sought legal care in some other state. And this gets especially complicated in many places where there are border states. Missouri and Illinois is a classic example in that, because quite candidly, many of the doctors that practice medicine on the Illinois side of the border in the Metro East area, some of whom provide abortion care, also live in Missouri and are licensed there. And so the fear was and is that they might be sanctioned, even if just simply forget criminal sanctions, just sanctioned with the denial of their license to practice in Missouri. And of course, there are reciprocal laws across the state that once a doctor loses their license in one state, they lose it in another. So Illinois passed a law that simply said for providers that if you are sanctioned for practicing medicine that is legal in Illinois, your license would not be impacted. The second thing that measure did was it created a fast track for licensing physicians who were coming to Illinois from other states and seeking licensure and approval in order to meet what is now a growing demand in Illinois to provide care, given that we are around in many states a sort of a refuge, a haven. We are the closest people can come. And so that was another element of this. And finally, what that law did was say that Illinois law enforcement would not participate in or cooperate with law enforcement from other states who were simply seeking information about people who came to Illinois to seek care. Because one of the things that people are at least concerned about as we move forward is once these laws are on the books, that someone may seek a subpoena about travel documents or other things to look at people who come to Illinois. And this policy simply says that we aren't going to be part of that. So for the moment, where we stand is 20 states with bans, others looking at efforts and ways to ban them. But places like Illinois trying to push back to create as many protections as we can. And meanwhile, I am not a political expert. I don't want to hold myself out to be. But I think the other thing that we're seeing is both in terms of public opinion and voting, we're seeing this pushback against the most draconian efforts to try to ban access to abortion care. You know, whether it's the rejection in Kansas or Kentucky of state constitutional amendments that would ban abortion, or whether it's actually what we saw play out in terms of the elections in 2022. There is, I think, a societal, in the body politic, there's a societal pushback against these kinds of bans. The fundamental thing is people don't like losing their rights. And so we're seeing that play out. And the last thing that I will say is that I think what we're seeing is, and this is, you know, listen, I work with the media every day, so I think that gives me license to make fun of them from time to time. It's funny when I do it to them, they don't think so, but I think it does give me that license. But I think what was interesting is in the run-up to the midterm elections last year, we heard a lot of people say, well, you know, abortion and Dobbs is really not going to be that big an issue. And then when you looked at the exit polling, it turns out that it is, that people do fundamentally care about being able to make their own bodily decisions, and their family being able to make those decisions. And so what we've seen as a result is you know, this kind of upswing against it. And I want to just close by saying, you know, that I think what that means for us as the ACLU is to keep finding every protection that we can in Illinois for two reasons. Number one, because we don't know what the next bad law that's going to come from some other state. And we need to be ahead of that to put in place all the protections that we can for people who live here or people who come here seeking health care. But I've come to understand over the last year that there's one other thing that we're doing. And it's funny, you know, one of the great things about being part of a national organization is getting to talk to people in states all across the country. And what we're really doing is showing people what it can look like when things get better. What it still can look like despite a Supreme Court that strikes down a super precedent in a matter of sentences. What it can look like to say that for patients and individuals, they ought to be able to make their own decisions with their doctor, with their family, with their religious advisor, with their priest, with whomever, without governmental interference. That is where we need to be. And one last thing. It's where we need to be, not just at the state level, but at the local level. There are efforts across Illinois, including in Danville, to pass local ordinances that attempt to limit abortion care. You know what? You may not pay attention all the time to who's on your city council. You should. You should, because it makes a difference. And those civil liberties issues like this are being debated right down to that level. And so there is a long fight ahead in this. And you know, in moments like this, I always think of my dear friend Jan Schakowsky, who taught me a long time ago, if we fight, we win. We will fight this battle, and I do believe over time, as dark as things may look in some places right now, we will win. Thank you all very much.